Hi, I'm Howard Snader. I'm the owner of the Snader Law Group. The Snader Law Group serves the Phoenix metro area and all types of family law matters. Today, I want to discuss 6 common questions addressing some of the more common issues about divorce and child custody. The first question that frequently comes up, and it's a very basic question, what exactly does custody mean? Custody is a catch-all term for both legal custody and physical custody. Legal custody refers to the authority to make major decisions for and about your children, including those decisions about schooling, religion, and medical care. Physical custody refers to how you and your spouse will share time with the children. It addresses where the children will live and who will provide care and supervision during specific time periods. Question number 2, how is custody determined in a divorce? Custody can be determined in one of 2 ways, by mutual agreement or if forced by the court. What will be best for you is one way an attorney can be of really great assistance. Even if by mutual agreement, I have found that parents that try to resolve the custody issues on their own without the help of an attorney often forget or don't consider several different circumstances. This can be a real problem as the children get older, circumstances change, or what was once an amicable relationship really does turn sour after the divorce. Question number 3, what should be included in a parenting plan? At a minimum, your parenting plan should address both legal and physical custody. In designing your plan, it's important to recognize that time sharing and decision making are 2 separate concepts. Each of those must be dealt with. In other words, parents who share decision-making authority equally need not also share parenting time equally. You can agree on just about any parenting time arrangement that works for your family, but important factors to consider include your children's ages, developmental needs, as well as the practical realities of transportation, work schedules, and living space. Your plan should recognize the importance of having your children spend quality time with both parents. Each parent should have blocks of both work time and play time with the children. Custody needs to consider schooling and religious considerations. Question number 4, what happens if we can't agree? If you and your spouse cannot hammer out a parenting plan on your own, then mediation really is the best next step. It's not always possible, but when it is available, I really would encourage you to make use of it. Because if mediation fails, your only other outcome is to take the issues to court. Litigation in court is costly, time-consuming, and from a personal perspective, it's emotionally wrenching. And when it's over, for all of your money, time, and tears, you will end up with a court-imposed parenting plan that realistically neither of you may be happy with. The bottom line, find a way to agree. Good attorneys can work these issues out and take much of the stress off your shoulders. Question number 5, my ex is a bad influence on my children. Can I keep them away from the kids? If your issue with your ex involves their parenting style, then honestly, probably not. For example, if you believe your ex is a bad influence because they feed the kids fast food or let them stay up late watching scary movies, you will need to work that out with your ex or learn to let it go. Courts rarely get involved in deciding who is a good parent and who is a bad parent. If, however, your spouse actually presents a real danger to your children, then a court may intervene to ensure your children's safety. Even then, supervised visitation may be preferred over no contact at all. Question number 6, we couldn't make our marriage work. How can we make our parenting plan work? Honestly, there's no magic formula for successful co-parenting, but your experience will be improved if you understand and accept 2 things about parenting plans. First, no matter how complete you think your parenting plan is, it can't possibly cover every situation that might come up. You're designing a plan that's going to last until your child turns 18. You really cannot predict everything that's going to come your way. Kids get older, schedules change, life happens. You really do have to be flexible. Second, your parenting plan is an agreement. It's a contract between you and your former spouse. It will work only if you both honor and enforce it. A judge cannot resolve every minor dispute. A court cannot mandate respect, mandate empathy, or mandate common courtesy. Those essential aspects of successful co-parenting have to come from you and your former spouse. If you have any other questions about custody issues or any other family law matter, we are here to help. The Snader Law Group is always ready to step in for you. Please give us a call at 602-883-2940 to schedule a free consultation.